Thanks,
Good
John.
evening.
I really appreciate it. Sorry.
This is John Milburn for Laws 12067, Environmental Law. We're into Week 10 of Term 3, 2017. We're now into 2018, in fact. The topic for this week is environmental litigation, criminal law. Misnomer, really, because what we are dealing with are elements of criminal law. We're dealing with issues of criminality, but in a broader context than just criminal prosecution. What I mean by that is that if we consider what's the content of Chapter 20 of Bates's textbook, we're really dealing with issues to do with the enforcement of environmental laws from the perspective of regulators. So what are the remedies for regulators, the executive branch of government, when it comes to dealing with environmental breaches? Clearly, criminal enforcement is one of those. However, as you would have read in the material in the study guides and also in your textbook, criminal law, where there is the creation of criminal offences for harming the environment, whilst very real, is used largely as a last resort. So what are those resorts that remedies, what are those remedies for regulators which fall short of criminal enforcement? Well, one is administrative remedies, another is civil remedies, another is enforceable undertakings, particularly in relation to agreements entered into, and then finally we have criminal prosecutions. So when you're considering what options might be available to you, if you're consulted by a regulator, or if you have an examination question that calls on you to give advice to a regulator, then my advice initially is broaden your thinking, and from that, depending on the nature of the question being asked of you, narrow your focus, possibly down to criminal enforcement, but it may be other issues. So largely I'll talk about criminal law, but I want the discussion to be held within the context of those broader remedies that are available for regulators. We have a couple of people online. Thank you very much for attending. If you have any questions, Kim or Justice, please unmute your microphones or ask through the chat facility. And for those of you that are watching this recording at a later time, please feel free to ask questions through UCrew and we can all engage in discussions. As I mentioned last week, I would like to see more involvement of students generally in the UCrew process. If we can't entice you to come along and join us live on a Tuesday night, that is. All right, so criminal law is all about criminal offences. That's pretty obvious. But sometimes what amounts to a criminal act, something which requires criminal enforcement, is not necessarily clear-cut, and regulators will typically work off guidelines and policies where not every matter which could become criminal prosecution results in criminal prosecution. In other words, there are different ways to take action to manage and stop environmental harm, and that might be through the civil law or the administrative law, where there are different options that are available. Just a quick refresher for those of you that haven't done administrative law, where you have decisions made by a government minister, department or statutory authority, they are called, as you might expect, administrative decisions. And when those sorts of decisions are made, the decision maker must follow correct legal process. That's all part of our rule of law. That's a very important part of the rule of law. If the process is not followed, the decision can be open to legal challenge. Whilst there are two types of legal challenge, primarily decision makers would find themselves on the wrong end of a judicial review application, which is where the decision itself is challenged on the basis that the decision maker did not follow legal process. The other type of administrative challenge is a merits review, which is a rehearing afresh. So bear in mind that when regulators make decisions, if you're acting for defence, you want to ask yourself whether the decision maker has actually acted in accordance with law, and part of your defence, even to criminal proceedings, might be to seek a lengthy adjournment to allow you to appropriately challenge the administrative decision-making process that led to the prosecution, and that would be done in a different forum. It wouldn't be done in the magistrate's court or the district court where most of the criminal proceedings are undertaken. it might be that you go to the Administrative Appeals Tribunal or some other tribunal or court, perhaps the Supreme Court, to deal with the issue of judicial review. It's a tactic which is available to you as a defence counsel. It's also something that you must be wary of if you are a government department decision maker. All right, so that's administrative law, and of course civil law is the contrast, if you like, to criminal law. And civil enforcement requires regulators to enforce proceedings in a way that is administrative. In some cases, members of the public can enforce civil through the civil courts, and we talked about that a couple of weeks ago. Remember, of course, that there is a basic distinction between civil law and criminal law in that the party that is seeking to prove something in a civil jurisdiction does so on the balance of probabilities, subject to the Briginshaw test, and the criminal enforcement is, of course, beyond reasonable doubt. So the remedies under civil law are different also to criminal law, and that's not surprising. So there are, in short, a wide range of options for a decision maker, administrative decision maker, to consider when seeking to enforce environmental laws, and there are consequently a number of different ways that defence counsel can deal with the issue, and sometimes the best way to defend a criminal proceeding is to try and take it out of the criminal courts and through maybe even a mediation, a justice mediation, to try and refer it to some other form of administrative or civil law procedure rather than criminal law procedure. So if in your examination you have a question that talks about the sorts of approaches that you might take as part of a criminal defence to someone that is being challenged for environmental harm, then you might want to consider that opening gamut of looking to divert through civil or administrative laws. And one of the best ways to do that is to look at the prosecutorial guidelines as set out by the regulator in their prosecution policies. If you can quote back to them their own policies, it makes it much harder for them to resist a good argument to the effect that the matter should not be dealt with as a criminal proceedings, it should be dealt with in some other way. All right, Kim or Justice, have I explained everything reasonably well so far?
That sounds good, John.
All right, Justice, that's good. All right, thank you.
Sorry, John,
yes,
I
Kim?
do have a question.
Absolutely.
So if you have an environmental issue, and it goes beyond an environmental regime of harming the environment, and it kills people in the process of that, I'm noting that there is a whole range of different avenues, and the defence is obviously different when it comes to applying to environmental law. I'm not sure I completely understand. Could you give me an example of what you've just relayed?
Sure. Well,
so I can just clarify that, please.
Let's take this for example. So you're consulted by a client who owns an activity, owns a business which is involved in dealing with the environment. There is an issue to do with environmental harm, but consequently upon the issue of environmental harm, let's say it might be say it's a quarry, for example. There may be some issues in relation to harm to individuals, and the approach that prosecutors, that regulators can take then might be to look at the matters purely from the perspective of environmental law issues, or to look at the matters purely from the perspective of criminal law proceedings, so prosecution under the criminal code for willful damage or for manslaughter, for example, if it's a death situation. Or a third way of looking at it might be for the regulators to consider other legislation, perhaps civil type litigation, such as work, health and safety. So there are a range of different ways that a particular problem can be considered from a prosecutorial sense. Within the confines of environmental law, there are also different avenues that can be approached, and the prosecutor can look at this, or the regulator can look at it from the perspective of administrative law, civil law, or criminal law. And generally speaking, if you're on the wrong end of criminal law proceedings, you want to get it out of the jurisdiction which could most readily provide for jail time and deal with it in some other way. I hope that answers your question, Kim. Is that a reasonable example?
Yes, I think I understand where you're coming from. Thank you, John.
Fine. Thank you for the question.
Hey,
All right.
John.
Yes, Justice.
I have a question just regarding what you've just said. Remember in assignment 1, there was the issue of Brandbit, and the council had taken him to court seeking a declaration that he had committed a development offense. Now, when I read the judgment, I didn't see the judge take any action against that. It's as if the judge did not make any declarations concerning the development offense itself. And I was just wondering how she could have gone about it.
Yeah. What I might do on that Brandbit matter, I'll provide some detailed feedback in relation to that assessment. So I might just reserve that for the feedback. Not everyone has submitted their assessment piece just yet.
Sorry,
Although I think we'll pass it up.
Sorry, excuse me, John. I fully understand where Justice is coming from, because I actually rang the real estate agent. I know people up there, so I actually done a whole range of research in regards to. I actually would like to defend Brett Fallon, but I probably can't say what I want to say in words in regards to maybe his negligent application of. Or he didn't even do any applications in regards to that. But I know we're all busting to get this first assignment out of the way, which raises, I think there was a couple of things on you crew in regard to our assessments. But I can't wait to do a debrief on this case. I would love to defend this person, but not in a capacity as a lawyer, but maybe as maybe someone in regard to the assessment manager or the council to actually help them to actually come up with some other alternatives, like resolution dispute would be a great way to start. That's where I think that all failed. And being in a country environment like I am in Moree, I can see that that's something that is lacking within the local government regime. So, sorry, Justice, you've done a good job to raise that question. Sorry, John.
No, that's all right. That's okay. No problem. Yeah.
I think we're all busting to get a resolution for this one.
And sorry, just to remind me, because it was the Whitsunday Regional Council and Brandbit. Is that the case you were talking about, Justice?
That's precisely the one, John.
Yeah. Okay. Well, look, perhaps we can explore that a bit. I think we're past the time where people are to lodge their material anyway. The first is, following on from what you said, Kim, about diverting the away from prosecution to something else. Justice mediation is an area that is, I think, overlooked. I'm a nationally accredited mediator, and occasionally I'll have lawyers that are defending someone come to me and say they've approached prosecution with a view to referring the matter to justice mediation on the basis that if it's successful, the prosecution will not be followed through. The prosecution will be withdrawn. And that's a very useful tactic generally that you need to consider. So it's a good diversion tactic, and it's based more on trying to remedy the situation rather than punish the individuals. So in that case of Brandbit, that was the one where the landowner was using the temporary accommodation for friends who camped on the land. That's correct, isn't it?
That's correct.
That's right.
It actually, sorry, Justice.
You're right.
No, that's all right. Go ahead.
Well, since there's only the three of us, that is correct. I looked into this case very, very closely because I used to live in Townsville and I actually know of this person. And I had access to just general information, but I actually literally rang around to the real estate agents in regard to change of use of land.
And you were
And
doing that in the context of the change of use for caravans and camper vans and tents, and you know, it
correct.
was historically a cattle property, wasn't it?
Yes, it was. And the property is, look, it's pretty run down. It's very run down. We did actually visit that property, but that would be just in transit. Now, my problem was for the fact for Brett Fallon, which obviously he's a disability pensioner. There's a whole range of things that I think back in the like it's not the outback, but when you buy property, you actually buy it on a belief that there is something already existing. And if he had have actually followed through with what the council was recommending, to follow through the application for change of use, and I think there was a whole range of things like there was a whole issues when you actually look into the court proceedings and the documentation for that particular court case.
Well, in that case, didn't the council invite an application for a development permit and encourage the owner of the property to apply?
Yes, they did. They did do that. From my research, from what I can understand, is that I think there was, personally, from what I can see from my investigation, there was abuse of power. It's a lot of problems that occurs when you're applying for DA's approvals and you're trying to, I suppose, move forward from an economic development area. You've got a bit of a hang up there because there's a lot of culture that comes into that process. And when people buy property, and I think from Brett Fallon's case, he purchased the property, like I think he's had it for over 20 years. So there would have been a lot of changes in legislation. So he hasn't actually followed through and he hasn't actually done the right thing, but I can understand where he's coming from, to be honest, because if you purchase a property based on what the real estate agents actually sell the property for, I think it was a sellable item because it was an old sale yard, and what the real estate agent was doing was trying to make a sale, and I think I'm not really sure, but I feel that there's a little bit of criminality coming into it, and that's why this case is probably working into week 10.
One of the reasons I set this case is it has a number of features. I mean, it's got the feature about the issue of applying for an accessible development and when it's appropriate for a development permit to be applied for. It also has the issue of how enforcement authorities can go about their work. And I could see, reading from the material, that there were attempts made to deal with the matter without prosecution, but that failed. So ultimately, the council relied on the provisions in the now repealed Sustainable Planning Act to establish that the landowner's accessible development required a development permit. So it deals with that issue of requirement for accessible development, having to comply with codes, and the remedies that are available under the old Sustainable Planning Act. There were issues to do with Section 603 and 604.
Look, you're absolutely right, but I just feel that there was so much more that could have been done. I can't call the man stupid for not, following through protocol. Like, I would never do that, but there was avenues there for him to do that, And I still think that there is avenues there to actually go under the economic. I looked at the the economic development policy for the council, and technically, because it's a tourist area, the council has an obligation to actually, under the Sustainable Planning Act, to actually promote economic growth and development. So it would come under the ED process to actually promote that sort of industry. And I think I don't know. Personally, I think I can't say that he's stupid, and I'm not saying that because I can't say that. But I think there was other avenues that he could have done, and being a self-litigant was probably his downfall.
Well, yeah, and there's a great avenue for people in practice to assist by taking on pro bono cases in appropriate circumstances, and you know, it's always better that people are properly represented. I'm not saying that self-litigants can't do a great job. Many of them can do, but you know, it's a complex matter, and I think when you're trying to argue that there was not a change of use from the cattle sale yard to providing temporary accommodation, there are some, you know, legal and factual issues that come into play there.
I actually, when it came to the section of the appeal, I chose to appeal on behalf of Mr. Of the company, Brandbid, but my reasoning was that the evidence did not support the conclusion, and I was looking at it more from the evidence law, the way the evidence was presented using photographs, and there was no witnesses who were called to actually ascertain that the photographs were authentic. So I was looking at it from that perspective. Maybe
no, that's a very good way, and that's exactly what I wanted you to do in that very difficult task of trying to think about how you would go about appealing that decision if you chose to do so. And there are issues of both the onus of proof and the standard of proof. Of course, there's the issue of who has the onus, and in that case, the court found that the onus of proof rested upon the landowner in certain circumstances when it came to proving the pre-existing use and incidental rights associated with that pre-existing use. But you're right. I'm not sure if was it all the evidence was photographic, or it wouldn't have been all the evidence. There must have been
part of the evidence, especially the one showing the camp events, and
the council certainly did use photographic evidence as part of its case, but I'm not sure it was the entire case. Yes,
no, sorry. You're absolutely right, Justice. Because I looked into this in great depth. In regard to what the council actually presented. Like, I used to work for a council, local government, and when I looked at the evidence that was actually produced in the first case, because obviously there's a whole range of like all the evidential stuff that was actually presented in the first case put forward, there was no expert evidence. The council ran around and they just basically made an accusation. Now, I'm not born and bred in Queensland, but we live in showgrounds, and we've been associated with a whole range of sale yards, and most of my work has been around that sort of area. And I've never known a sale yard or a showground not to have accommodation available to people that bring in cattle and they bring in horses. There's a whole range of activities that's associated with the sale yard. So you're absolutely right, Justice, in saying that there wasn't enough evidence to suggest that this Brett Fallon was actually in breach of anything other than what he may have purchased as a true property to go through with a historical, like he may have felt like he was going to restore the sale yards. And historically, that's what sale yards are. You don't have cattle and you don't have um, animals without having people and be able to camp there. So there's a whole range of things the council had failed to do, and there was no expert evidence in the first initial case.
And when you were reading the case, were you considering the way in which Her Honour applied the Brigginshaw test, the sliding scale?
Yes, I did. When I looked at that, basically it's sort of, because I mean obviously that case was related to a marital or divorce scenario.
That's right, we talked about this last week, didn't we?
Yeah, and the test, look, I just failed to actually see the relevance, to be honest. I can't see why Her Honour, and
I wasn't able to persuade you last week. I won't be able to persuade you this week, will I,
no,
Kim?
I just cannot see the regime where you can have look, the test is one thing, but I don't think the test was actually appropriate to actually apply that at that particular point in time. My thoughts were the first thing that Her Honour should have done is put it back to mitigation. Go back to ADR and put it back to the parties to actually have a conversation. Because there was nothing there that I could see that actually really led for any communication. I mean, the worst part of all this stuff is there is no communication. And if you've got council versus a property owner, it's always going to be war. So you've got to have litigation or some sort of litigation there to, ADR should have been first priority. That's my thoughts.
Yeah, and
I
of
know,
course,
we had this discussion last week. I'm sorry.
we did. Yeah, we better keep moving on. But in that case, the council brought the action eventually, I suppose, as guardian of public rights, and did so in a way of trying to promote the other business operators. I suspect behind the scenes that there was a lot of pressure from people that were in business who saw what the defendant was doing as being an unfair competitive advantage.
Well, I actually researched on this, and there's only one caravan park located in that area.
Well, I might be wrong. I'm just surmising. I was just guessing.
I actually got onto the register and looked at the PID and looked at all the different complaints from the council's perspective, and I think he's got a raw deal, but he just wasn't able to communicate properly, and because he's disabled as well, and he did have a horrific accident many years ago. I just think they just need to bring someone else in to help him to understand his obligations. He was wrong. That's my statement. He's wrong with what he's done. But I think they could have done a little bit more. But councils, it's dog eat dog sometimes.
Well, and I think you've both made excellent points. And another reason why I selected that case is I think there is something in it that would allow you to consider an appeal and raise some arguments. And just as an aside, Her Honour Justice Judge Boskill, as she was then, was recently elevated to the Supreme Court from the District Court. So Her Honour is now Justice Boskill. All right. Now, is there anything else that we want to discuss about that case, or should we move on?
You can move on, I guess.
Well, I think we're all good. Are you happy, Justice?
I'm good, Kim. I think we can just move on. Thanks.
All right.
All right.
Okay.
Thank you.
So what we can see from our discussions are that there are different ways to deal with certain things. And primarily because I work in defence, I look at some of these things from a defence perspective, but it's very similar from the prosecutorial perspective because there are these range of things that you might want to consider before you get to criminal law. But once it does become a criminal proceedings, you need to consider the different classifications of offences, indictable offences or summary offences, and you need to consider what defences and privileges are available to people, Last week, Kim, we spoke about self-incrimination, and I said, no, we'll have a chat about that this week. So I gave that some thought during the week, and my original thought that the privilege against self-incrimination applies just as much to environmental offences as it does any other type of offences is still my opinion. I don't see any exemptions to that would apply. So unless you're brought before, say, the Crime and Corruption Commission or the Australian Crime Commission, where there is no ability to claim privilege, then you still retain that right. Kim, do you have a different view on that? Because you raised the question last week.
Yes, I do, John, because when I was looking at under the, because I'm looking at Queensland EPA, I'm looking at New South Wales, I'm looking at Tasmanian EPA. When I was looking through, like, my example is, if I've got a quarry and I'm working under the mining legislation, which changes between Queensland and New South Wales, if the EPA inspector comes in and they ask me to divulge XYZ, I have to actually answer that question. I cannot say, like, once upon a time, under a different legislation with the safety or mining legislation prior to this all coming through, I could say nothing. I had the right to say nothing. But under the EPA, I'm sorry, I just can't actually, I have got it written down, but I can't actually cite the actual, under the acronym, the EPBCA.
EPBCA, the Commonwealth.
Thank you, yes, because acronyms don't work well with me. But under that legislation, they actually state that if you are asked a question, you cannot turn around and say, I have no comment. You must make a comment.
Okay.
And that makes you self-incriminating. And when I was looking through that, because I'm trying to look after quarries, concrete batch plants, I'm looking after with what I do in my work, and I'm looking at that and I'm just going, well, if you can't have that right to silence, and I think that's why I raised that with Justice when we were talking about the first assignment. I didn't raise that in my assignment, but I wanted to, because you have no choice. You must answer and you have no choice. So you cannot turn around and say, I'm not going to answer this question because it might self-incriminate me. You must answer it whether it's self-incriminating. And I'm just thinking,
I haven't been able to persuade you otherwise.
No, I know.
I wonder if I could ask this favour, given that I wasn't able to find the provisions that you're mentioning. Do you think that you could post the sections on UCRU and we can have a look at those? And I would be very happy next week to indicate that I'm wrong, but I can't see it at this stage. So at this stage, I'm prepared to concede that we agree to disagree, but I can't see that there's a mandatory requirement to make a statement that would have the effect of overriding the general rule, the general principle, giving a privilege against self-incrimination. Justice, have you come across anything?
Hey, John, I actually have a question. I'm wondering whether we are talking about two different rights here. That's the right to say nothing, right? And the right not to self-incriminate yourself. So you can say something without incriminating yourself. And I thought, that is different right, different from the right to actually incriminate yourself. So I don't know whether, we're talking about two different rights here sometimes.
And we might be, because the area that I'm talking about, where I say there is a privilege to refuse to make a statement against self-interest, is only in the context of criminal activities. So anything short of that, I don't believe that there is that privilege. So you're right, Justice. Kim and I might be talking about different things. let's explore that during the week through UCRU. And Kim, if you're able to provide some provisions or some commentary, that would be excellent. Likewise, you, Justice, if you can.
Look, John, I will. I've done a lot. Majority of my work at the moment, because I'm on in Queensland, is around the EPA in New South Wales. I've looked at this extensively because I suppose my role in my job, I do compliance. I'm supposed to be a safety advisor, but I'm doing quality assurance, I'm doing environmental law, I'm doing safety as well, and I've got to deal with a range of legislative requirements with the quarries, and there's a whole range of things. Like since New South Wales, since the work health and safety regime, this harmonisation thing come into place in 2011. It's just opened up a whole can of worms. And my job is, and I'm holding my hand on my heart at the moment, is to protect my business and protect the people that work within the business. So I'm dealing with heavy haulage. I'm dealing with quarry. I'm dealing with mining. I'm dealing with concrete batch stuff. So everything I can see when I'm looking through the legislation for New South Wales, and I must admit that it's New South Wales, not Queensland.
That's okay. You can share the information on New South Wales on UCRU. We'll have a look at that.
I'll probably not sleep for the next 12 nights. I'm trying to get all this stuff done, but it's very important, and I think there's a loop. There's a loop and there's a gap. Because I think when the government, and I'm not sure where it actually changed, but from 2009, legislation was pretty well across the board. It was very clear with mining, quarries, and construction. But all of a sudden, there was just a gap. There's been a big dip, and for the information, look, I'll have to do extra research on this because I think it's very important.
Well,
and everyone in this area probably they might not realise it now. They might not be to the end of the breed that I am, but it's very important. And I think there is issues in regards to being able to not say something. Like, you have a right to be heard, but you also have a right not to be heard unless you're represented. And I think this is where the legislation falls down, and that's what I'm finding at the moment. But I'll go through and I'll trace that. And okay. I know we've had a little bit of a debate on this.
No, I look forward to it. That'd be excellent.
Okay, sorry, John.
Right.
Thank you.
No, that's great. Thank you very much, Kim. I appreciate that. So what we've been talking about are potential defences. There are and strategies, really, even before the prosecution comes about. There are some special rules that apply in environmental law when it comes to corporate liability. So there are some issues about vicarious liability of the corporation. There are some special corporate defences that applies. And when it comes to actually punishing someone who has convicted, then there are two ways of doing so. One is, I guess, sentencing through the ordinary court process, and the other is to bring contempt proceedings. There are a couple of cases in the study guide about contempt proceedings where environmental laws have been broken, or more seriously, orders of the court which relate to environmental enforcement have been breached, and the courts, you'll see, don't take kindly to that. Make sure that you're aware of the category of offences I mentioned briefly before: summary offences and indictable offences. There is a hybrid: indictable offences that are dealt with summarily. In general terms, very, very broadly, indictable matters for the higher courts involving a jury, summary matters for the magistrate's court, but some indictable offences are dealt with summarily. So there's a mixture of things that apply there. But if it's a summary offence, there are some time limits that apply. So one of the best ways to deal with an issue of a prosecution of a summary offence is to say that the time limits are not met and the matter cannot proceed on that basis. What you need to do is consider the act that in question. For example, have a look at section 494 of the Environmental Protection Act, and that deals with the issue of indictable versus summary, and sets out when does an offence transition from being a summary offence to an indictable offence. It's there in the legislation. So, and you find there are different rules that apply in the Commonwealth as well. So there's not just one answer as to what is required for an offence to qualify as being indictable as opposed to summary. So have a look at some of the offence provisions that relate to time limits. For example, under the Vegetation Management Act in Queensland, 1999, if there's an offence against a matter which is summary, then the proceedings, as is typically the case, must be commenced within 12 months of the commission of the offence. That is coming to their knowledge. But in the Vegetation Management Act, there's a further rider to say within 5 years after the offence is committed. So, you know, a couple of time limits that apply there. We've talked about the EPBCA tonight briefly, and there are certain provisions in the EPBCA that give rise to potential criminal prosecutions, and have a look at issues to do with actions that might have a significant impact on a matter of national environmental significance, where you can see that there are potentially long terms of prison that might be imposed or substantial penalties. If you look at the Australian Government Department of Environment website, there are some issues there about compliance and enforcement mechanisms. And just a brief reminder, as I said at the start, when you're looking at defending matters, one of the best ways is to look at the prosecutorial guidelines. The DPP guidelines in Queensland are available on the Justice Department website, and that will give you some idea as to what it is that the DPP will do when considering prosecution under under environmental law offences. The other thing that you've got to consider is the issue of intent. Yes, sorry, Kim.
Sorry, John. I know you're a fantastic defence lawyer, but I would like to be a prosecutioner.
Oh, yeah, prosecution's great. Yeah, I've done a few.
I would actually like to know if people are doing the wrong thing. Doesn't matter whether it's criminal, civil. It's to do with environmental issues. Like everything I've studied with the law, all I'm hearing is about defence. Everything I see in relation to criminal law, they always fail because they're the prosecutioners. So why does defence always win versus prosecution? So if I want to be like, I mean, like this is very serious to me. Like I'm just going like, you can defend people. Look, I wear my heart in my sleeve, and that's why I'm not going to be a lawyer. I won't do that because I wear my heart in my sleeve. But if I'm going to defend somebody, I want to be a prosecutioner. I want to know how to be in regard to the EPA. How do we actually prosecute people? Because I don't see that in the legislation. I don't see anyone going to jail. I see that there's like under the offset program, like the government. It depends on what's government in house. They're happy to say, look, okay, well you buggered up here. You've killed all these animals. Well, we need to have you go and fund another program, just to go and go, like, you know, this is the way we're going to go with this. I want to know how to prosecute somebody. I don't want to know how to defend somebody. I want to know how to prosecute
I think
people that
those that are in the
that are doing
prosecutorial,
the, like, in breach of all the legislation. Like, workplace health and safety is my that's my bread and butter. Environment is very much my love and my passion. I come from Tasmania. I've seen everything. I've been associated with some of the most horrific court um, trials and things, and with the grannies and all that other stuff. But I want to know, how do you prosecute someone? Because no one goes to jail.
all right. Well, that's a really good point, and prosecution work is excellent, particularly those that have a passion and are fair-minded. I think you need the two, and the prosecutors that I've come across are both. I think it's fair to say that people do go to jail, but you're right. I think historically, environmental law offences were seen as being victimless offences. That is changing. The penalties are becoming more substantial, but it is difficult for prosecutors to secure a sentence that does involve actual time of imprisonment. Even the examples that I've given, there are many examples of very high fines that are imposed for environmental breaches, but not too many where there's actual imprisonment. Sometimes it takes a contempt situation before the courts will actually imprison. But I wouldn't go so far as to say that no one goes to prison. They can and they do, but it's it takes a lot of evidence and a lot of work to do that.
John, could I make a recommendation for I'm like, for my whole law degree, I've been I suppose people have actually talked about the Tasmanian Dam case. Let's go and have a look at Mount Lyell in Queenstown. Have a look at the things that's actually got away with that particular case. There's a whole range of things that, like,
I'm just going to. I'm very conscious of the time, and I think we probably should be exploring some of these things on UCrew. But look, I'm sorry to cut you off there, but
yeah,
I will let you. I'll let you continue, but maybe not for too long, if you don't mind.
No, I'm going to put it into 2.5 words. Look at Mount Lyell in Queenstown. Look at that environmental issue there, and look at the ramifications that's actually come out of all the court cases, and look at where it is now. Four stages, because environmental law, or environment law, if we're going to be serious about those, you're I'm sorry, John, I don't mean to get you offside. We're going to have a little bit of debate. You're on the defence side, I'm on the prosecution side, because I will actually want to see things happen a little bit better than what's going on. And if you're going to use Tasmania as an example, maybe that's a great way to look at breaking it down into sections, because Tasmania is not a very big place, but there's a lot of stuff going on. Yes, we'll differ on a few things, but I'll come up with, before we finish the session, something to move on with. And criminal law is not something that I see EPA has been involved in. I just see it as a smudge. The EPA can only administer a range of penalties as a defence to be able to go, well, you're going to be penalised for this. You need to pay $3, $4, $5 million to go out to Queensland and go and do something. Like EPA, like, there is no, under the Commonwealth regime, they can distribute that money anywhere as a penalty. I'm not seeing anyone actually really being severely hit. Like, the back pocket obviously is where it gets hit. I'm not seeing people really getting, because we're dealing about corporations. We're dealing about people with, deep pockets under corporation law. And that's something that I'll probably have to have another conversation with you before we finish. But look, John, you've done a fantastic job. Thank you for listening. But there's a whole range of things that opens up with this discussion. I know you're watching your clock. You probably haven't had to dinner.
Oh, no, it's fine. Oh, don't worry about that. But
well, I would actually, like, maybe moving on for the next course, look at something that's a little bit more passionate, because people are looking at, I suppose, what we're doing with our course, but it's not going to fix anything. I would assume that you would like someone to come through your course and make a difference. And I'm sorry, I'm an advocate. I can go through defence and I can go through prosecutions. I would actually like to see something in the regime of what we're doing for assignments to actually say, well, we can actually come up with something, a solution. And I think you're right. ADR is definitely the way to go. That's the first step. It deals with marriage breakups. It deals with a whole range of things. Communication and talking and mediation is the best way to stop the cost of the government running around spending so much money on all this litigation stuff. Going back to the Brett Fallon, if he had have actually had someone there to actually help him along the way, I reckon he would have been all right. He would have been. It wouldn't have been a court case.
I'm just going to stop you there. You mentioned people making a difference through this unit. I've been taking environmental law for a few years now, and I'm very pleased about that. But I was given permission to share this quote. I got an email from a student a couple of years ago, and Rob Bowers, his name. He was a student of mine in environmental law, and in part, his email to me the following year was a lot, or it might have been a couple of years after he did the course. Rob said, I had a bit of a win on the Grantham Flood Commission of Inquiry 2015 in that a presentation highlighting faults in the hydrology report caused Walter Sofronoff QC to request supplementary supporting documents to be created. The Mount Morgan mine wall in danger of collapse appears to have had reinforcement, so protecting 1,200 lives. Not sure if it was anything to do with me, but certainly the DRM operator in Rocky knows my name. The above information is to show you that your teaching makes a difference to society. Just a little jitty for you, John, to let you know that we did listen, and thank you for your engagement with the Central Queensland University establishment. Attending this campus has always been a dream come true. So I'm not making that comment because there was some positive comments about me, but just to highlight, Kim.
That was fantastic. Sorry, I just want to, like if it was in court, like I would never go to court because I don't shut up. But yes, I do know him. I've been to Mount Morgan. I know the area. I used to live in that area. And yes, every single thing that everyone does, even if you don't use this law degree to actually be a solicitor or a barrister, but you can actually use this degree to change the world. And yes, I do know this of this person, and I'm not saying I've been a runaround forever, but I have travelled Australia, and I live the dream. We live in a caravan. We work around all the communities, and we do work in a lot of high, I suppose, environmental controversy industries. But John, you're fantastic, and everything you've done for this course, I want to know more. Like, I don't know how to say this to other students. It's not about making money. It's about, well, it probably is from a solicitor's point of view or a barrister's point of view. But you are so on the money with what you're doing. Because well, I can't say anything, but
Oh, no, thanks.
Doherty, in regard to law, and Hamer is my relations, and they're all massive solicitors in that area.
Okay.
But I think, John, you've done a
Oh,
fantastic
thank you very much, Kim. I appreciate that.
And I'm
And
going to let you go.
thank you
Sorry.
both for your patience tonight. I've enjoyed our discussions. It's been really good. And I think, as I mentioned at the start, the unit guide, the study guide that I prepared for this week is very comprehensive. And if you haven't had an opportunity to read that, please do so. And some of the things that we've discussed tonight are in the study guide, but there's other material that we haven't covered. So I'd recommend that we that you do look at the study guide. You won't need to look much beyond the study guide in terms of this unit, but if you take up on Kim's suggestion, once you start to read the material, it'll just incite more enthusiasm to read elsewhere. All right, well, we might wrap it up for this evening. Justice, thank you very much. Kim, thank you very much. And we'll see you next week. Any closing questions or comments?
No, I just want to thank Justin to actually turn up to have this discussion on the first assignment. John, what you presented, like you can take what you find, but if you keep reading and you keep getting involved in what's going on and asking questions, like I don't agree with you all the time, as we haven't, agreed completely on stuff. But I mean, you're the boss. But I don't know. Like there's some things I'm just going, well, it's all changed.
I'm always very open-minded, so I'm very receptive to people contributing. And that's part of the reason I use UCrew and I encourage UCrew, because it provides everyone else a chance to contribute material. It's not just from the unit coordinator. And I do like that. And I learn things as well, which I also like.
Well, I think I've got a couple of things I've got to portray. Once the subject is over, then you go, like when you do a course, you actually you do your assignments and you just panic and go, I have to do this. But it's not until it's finished you go, and then you have reflection. And then you go, right, I can see your point of view, but I don't agree with everything you say, to be honest, because
No, it's fine.
that's not how it goes, like in the real world when you're actually dealing with the individual departments. With the regulated departments, like you've got a whole range of things that is, I suppose, it's very frustrating because there's so many laws you can look at, so many regulations, so many acts. You've got your local government acts. Like I've got.
There's a lot. Yeah, there's a lot of material. All right. Well, anyway, Kim, sorry, we'd better wrap it up. Otherwise, those people that are watching on the recorded session will
they're going to be lost anyway.
They'll be going too far. All right.
It doesn't matter. They need to actually join in with what we're doing, because at the end of the day, it's about discussion. I learn from every time that we have a tutorial. Justice, he raised some great questions.
He did. Thank you, Justice.
And I've got to actually go and have a look at what he suggested as well. It's all about learning. It's about being associated with people that has different views, because the law has different views, and we've got to, if you're going to go through the defence side of it, you've got to have all your ducks lined up to actually be able to go, this is my defence. If I'm going to go through prosecutions, I'm going to lose anyway. So I'm not going to win.
You're too negative.
I'm not going to win. I've looked at all the criminal law side of it. Like that's the basis of this week 10 is criminal law. I don't know how you win. You win from a defence perspective, but how do you win from a if you're gonna put your information together, how do you win from the prosecution side? I don't think like if you got prosecution versus defense, defense always wins. How do you win on prosecution? I want to know how you do that. And I'm studying very hard to
Good
learn
food for
how.
thought.
Yeah.
All right.
Well,
Yeah.
that's
Well,
how it is. Sorry,
let's
sorry,
think about
John.
that during the week. All right. All the best. We better end the meeting. And
Well,
thank you for
that's for
attending.
next week.
That's for next week. All right.
Thank you, John. Thank
See
you.
you then. All the best.
Thank
Bye
you.
now.
Hooray.
Bye.